Let's assume for a moment that he doesn't have any idea what's in the boxes in the basement of his Florida residence.
Right.
Let me ask you this. Does he know what's in his desk?
I would think that he probably would.
Why was there a classified document found by the FBI with their search warrant in his desk?
Part of the problem there, I can't answer that because I don't have an inventory to know what it was.
Here's what we know. Classified document found in his desk. Without knowing what the document is, what we do know, it's a marked classified document. It's in his desk, okay? It's not down in the basement in a box. It's in his desk. All you need for a criminal case is one of these. That's all you need. So you've got one very, very smoky gun in his desk. And there's never been a word of explanation from the defense team or from Donald Trump about that document, which is the smokiest gun you've got in the whole thing.
If we knew what the document was.
No, because you don't need to know what the document is.
No, you do.
Here's what it is.
You absolutely do.
I'll tell you, I know exactly what it is. Here's what it is legally. It's a government document. He has no legal right to possess it. It's in his desk. And as you've said quite correctly, the classification issue isn't really that important in this case because that is not what they used to obtain the search warrant. What they used to obtain the search warrant was an obstruction element of federal law that does not require the government document to be classified at all. So you don't need to know. You don't need to know sitting here exactly what that document was to know that Donald Trump, if he doesn't have an answer to what that document was doing in his desk, a legal answer, that is a crime for that document to be in his desk.
That's not necessarily true. Okay, you do need to know what the document is. Okay, simply the fact that it has a classification marking on it, if it does have a classification marking on it, doesn't make it automatically some type of contraband. It has to be national defense information, one. Two, under the Presidential Records Act, we're talking about original documents. Not a single one of those marked documents are originals. They're all copies, every single one of them. Now, when we talk about, for example, if he has the original, letter from Kim Jong-un in his desk, that would definitely be a government record because that's the original. And so under the Presidential Records Act, which makes a distinction between originals and copies, then you can talk about whether he's possessing a government record. But whether that's classified or not doesn't really matter as so much as does it constitute national defense information. And so if he has a photocopy of a document, even if it does have a classification marking on it, but it doesn't constitute national defense information, or if it was declassified, if it's not currently national defense information, then no, that wouldn't be the smokiest gun.
Okay.
You do need to actually present what the documents are.
I want to go back to your point, which is correct in the Justice Department's approach to this, which is classification is not important to them in this investigation. And the reason,
it's not part of the statute.
The reason for that, that's right. And the reason for that is the heaviest thing Donald Trump is facing, the heaviest statute that they cited in obtaining that search warrant, 18 U.S.C. Section 1519. And you know what it says. And you know what the final line of it says, which is 20 years. Okay? And here's what it describes. Word classified never appears.
Correct.
National defense never appears. This law applies to, as you know, any record, okay? Whoever knowingly conceals, covers up in any record document with the intent to impede, obstruct, or influence an investigation. And that is what they believe they have in Donald Trump's desk, with his full 110% knowledge that it's in his desk because they served a subpoena. As you know, you were there, you were on the team. You were there the day they got that subpoena. They get a subpoena. You guys get a subpoena that says, give us everything, okay? And as we all know, the FBI and Jay Bratt, Justice Department, come down to the legal team. You hand them this document that says, we're giving you everything, and it turns out it's not. And because they know it's not, that's what allows them, that moment of obstruction right there, where Donald Trump, through his lawyers, is saying, I'm giving you everything, not a press release, not a I'm giving you everything.
Well, which is not what it says.
Okay, I know it says...
It doesn't say that, and that's unfortunately one of the misnomers.
Tell me what you think the loophole language is in that document.
It's not about loophole language. It's not about loophole language. That is a standard form of a certification.
It's not a form. The audience shouldn't think it's a form. It was typed word for word, written word for word by Evan Corcoran. It's not.
You want to let me answer this?
Yes, but it's not a government form.
When you receive, no, it's not a government form. No. It's a legal form. Okay, well, what happens is this.
It's his composition, word for word.
It is Evan Corcoran's composition. Mm-hmm. And what happens is when you receive a subpoena for documents to a custodian of records, there's a relatively standard custodian of records certification. Each lawyer will maybe draw up their own particular form, but ultimately, every time you respond to one of these, you don't sit there, open up a brand new Word document and type it out from scratch. You take one that you've done 20, 30 times before, you change the names. But here's the thing. When you have a custodian of records subpoena and you put in a certification saying a diligent search was conducted and all responsive documents are attached, what you are certifying is that everything that you found during that diligent search is attached. No lawyer is going to then say, as has been misreported in the media, no other documents exist. Nobody's going to say that.
No, and that's the difference. You know the law doesn't need that sentence.
But here's the thing, is that ordinarily he asked for more time. He did not get the additional time that he wanted. He wanted to be able to do a more complete search.
He had a year and a half.
No. He did not have a year and a half. He had a few weeks.
All right. So
no. Hold on a second, because this is an important point.
Yeah.
When he received the subpoena, he had a few weeks to respond. He needed more time. DOJ refused. Ordinarily, in any other circumstance, when I'm dealing with a prosecutor and I say I need more time, they'll either give me the more time or they'll say, hold on. They will say, give us what you can and keep searching. Jay Bratt didn't do that. He gave him a deadline. It must be done by this time. He did as diligent of a search as can be conducted in that time. He gave him what they found in that time. And then it was cut off. What they should have done, if DOJ was going to be acting like normal professional prosecutors from any other U.S. attorney's office, they would have continued to work on this and said, okay, continue to search, continue to do this, find whatever else you can, and give it to us. They didn't do that.
When you were a naval officer,
yes,
if you had a classified document in your desk at home, and the government spent over a year, trying in this cooperative way that you're talking about, to get every government document that you might have at home back from you in a free zone, no harm, no foul, if you give it back. And there comes a day when you give back what you are telling us is all your documents, and then the government discovers they didn't give us back everything. And so the next time the government asks you for something, they do it with a subpoena. And when they do it with that subpoena the second time, after you spent more than a year not giving them everything when you finally gave them something, how much of an extension of time would you expect from the government on that subpoena that's chasing what you were supposed to give them the first time you gave them documents and you didn't?
Unfortunately, your hypothetical departs widely from the actual facts. During that first year, they were discussing it under the Presidential Records Act. At no time did NARA tell President Trump or anybody on his team what they knew from 4 decades of experience, which is that these boxes generally contain a mixture of documents. Instead, what they did is this. They wanted all of the records returned to NARA headquarters here in D.C. Mm-hmm. Every other president, from the signing of the Presidential Records Act, Reagan on forward, NARA would get a facility where that president moved to. Mm-hmm. They would have all the documents housed there so that over the next 2 years, because under the law, the former president gets 2 years to go through all of those, decide what is personal, what is presidential. For Donald Trump, they chose not to do that. In choosing not to do that, that is what caused the General Services Administration, another government agency, to move all the documents from the White House to his house in Mar-a-Lago. The same thing that they do for every vice president. That's why you find documents in Biden's house. That's why you find documents in Pence's house. For the next year, they're asking him to send all the boxes back to D.C., not to be able to go through them, as every other president had, not offering him, we'll get a facility in Palm Beach so at least you can continue this process. They're saying, don't go through them, send them back. And he's sitting there saying, under the statute, I have 2 years to do this.
Okay.
But you cannot take that period of time and then the subpoena and just mash them together and act as if it's a continuous thing. These are two totally separate things.
Okay, so let's just accept all that, okay? And there's a lot of things to argue about, which we won't. We don't have time. In the year and a half, when Donald Trump wants to use his time to go through these boxes to find out what should be sent back and what doesn't have to be sent back, how many boxes did Donald Trump go through?
15 boxes were returned in January.
How many did Donald Trump look at? Any?
You would have to ask him. I know the 15 boxes were returned. I don't believe that he went through them that carefully, because certainly when I went through them, I saw things that were clearly personal records. But
did you personally find classified documents when you went through the boxes?
No, I went through them at the NARA headquarters. I went through them there where the marked documents had already been removed and they were replaced with insert sheets that said, you know, here within the box is where we found, you know, this document, this title, this classification level.
Right.
And so we were able to kind of reconstruct what was in the boxes from that and understand how these documents related to everything else in the boxes. So
I got you.
So yes, I did go through that.